Good afternoon, everybody. My name is Colin Crawford, and on behalf of my colleagues Niki, Boddie, and Kathleen Hicks, we'd like to thank you for being with us on this chilly Friday afternoon for our presentation on electronic signatures. Before we begin, we'll just give a brief roadmap of some of the things we're going to be talking about this afternoon. We're going to be talking about some definitions and examples of what an electronic signature is. It seems a little straightforward, but in fact, there are a number of ways that we do it every day without even realizing it. We're going to talk about the history of some of the legislation dealing with electronic signatures, both here in the United States and abroad. We're going to delve briefly into some case law to see how this legislation applies, where courts have found these types of transactions enforceable or unenforceable. Next, we're going to be dealing with exploring some client strategies for avoiding validity disputes and some issues that may arise during litigation. And finally, we're going to be talking about the upcoming trend of e-notarization. And so before we begin, it's important to note that none of us are lawyers. We are, until we get our licenses, we humbly remain detached scholarly observers, so nothing in this presentation should be construed to establish an attorney-client relationship, nor is any of this intended to be legal advice. This is for enlightenment and edification only. And with that, we turn to Niki for some definitions and examples.
Thank you, Colin. So to start us all off, what is an electronic signature? Electronic signatures actually encompass a broad scope of ways an individual can show their assent to a contract or any document for that matter. The definition of an electronic signature is a symbol or process attached or logically associated with an electronic document that is executed, adopted by a person with the intent to sign the document. So it can be any means. A symbol, a process that encompasses a wide variety of ways somebody can actually sign a document electronically. And an electronic signature carries the same legal implications as a handwritten signature. Common forms of electronic signatures include going to the grocery store. When you check out at the pad at the end, that's an electronic signature. When you receive a package, that's also an electronic signature when you sign the form the UPS guy or the USPS guy hands you. Additionally, whenever you're online, you click I accept or submit, and there are terms and conditions you've agreed to, that also counts as an electronic signature. So this is something that's pretty pervasive within our lives today, and everybody does it without perhaps even realizing it. An additional form of an electronic signature can be a PIN that's given to you that you use on online websites. Because signatures can be any symbol, this also includes numerical signatures. So this is an example of the PIN website for federal student aid. And for example, you could use that for student loans. You can use a PIN number for something such as taxes, federal or state. And in some cases, debit cards you use a PIN number, but in particular, student loans and taxes are most important because they are federal agencies, and where governmental agencies have accepted electronic signatures, they must accept that form of electronic signature that they have said that they will accept. Now, Wake Forest's very own Professor Davis will share a few comments on e-commerce and the role it plays today and where he thinks it's going in the future.
My name is Timothy Davis. I'm a professor of law at Wake Forest University School of Law. And Niki, I'm pleased to answer or share some comments with you concerning e-commerce, which I think is a great innovation. Indeed, I think that the laws that have been developed with respect to e-commerce are certainly a very good illustration of how laws can support the way in which people and entities transact business. And in that sense, it will certainly help to facilitate the greater efficiencies in business operations. What's interesting about it also is that parties were already transacting business using electronic means, so the rules relating to electronic commerce really validates what they had been doing in any event. So it's a good illustration of how law really comports and conforms to and supports the way in which entities and individuals conduct business.
So what do electronic signatures do? One article addressed the 5 functions electronic signatures provide those involved in the contracting process. The first of which is an evidentiary function. This provides admissible, reliable evidence should you have to go to a litigation, and satisfies the statute of frauds, which is required in a number of contracting cases. Second, there's the cautionary function. This involves making sure that the person signing the document feels the weight of the legal consequences they are going to have to deal with by signing that document. There's that sense of, I am bringing this upon myself. What I have signed, what I have assented to in this agreement represents what I'm actually going to do. That electronic signature is just as powerful as an actual handwritten signature. Third is the reliance function. And this is something that puts it on record so that the reader or the recipient of the contract has something they can rely on, and that allows protection for the individual that is receiving the document and reading and relying on what the contents therein. And fourth, there's the channeling function. This is just a clear way of proving intent. It gives, clean cut, these are ways that you can provide an electronic signature that really provide, your assent and intent as somebody signing a document. And finally, record keeping functions. Now, this is typically used more by the government, and especially in the real estate function. Here, the documents are kept by the Register of Deeds, and it just provides an easier way for the government to control records. And as we move along with technology, businesses certainly could use this sort of technology to move their business along and keep records in a more concise, easy manner so that there's less parties intervening and third parties touching documents and potentially messing things up or losing documents. Now, two types of signatures are often talked about along electronic signatures. It's easy to confuse the two, but they're really one and the same. Electronic signatures and digital signatures are typically the words you hear. First, an electronic signature is any method which applies a signature to an electronic document or contract. A digital signature is a specific subset of electronic signatures. It uses encryption technology to provide security and protection from fraud, and the recipient who receives the document can then see if the document has been altered since it was signed, or if indeed that person doesn't have the key, they won't know what's actually in the document at all. Because of its security and prevention from fraud, this is often one of the most common types of digital signatures used, or electronic signatures used. In order to fully understand digital signatures, it's important to understand the process. So referring to this flowchart, we begin with a message that is created by the sender. From that message, it is then encrypted using an encryption algorithm with the sender's private key. These two keys are the critical piece to this puzzle. This is what encrypts it, allows users to use it, and provides that checkpoint to make sure that the signature has not been altered. If you look at the sender's public key, that is the key that allows the receiver or the recipient to unencrypt the message, understand what it says, and see the contents therein. This document is sent in two ways, once with the encryption keys and once without. The two encrypted messages are then compared at the end, where if they are the exact same, the document has not been altered, so you know it's secure. It actually has the signature, nobody has changed anything, there's less chance for fraud. However, if the two messages do not actually work together, then an error message will come up and the recipient will know this document has been altered. It is not the original document. In fact, in some states, by using these two keys to encrypt and unencrypt the code to make sure it hasn't been altered, creates a rebuttable presumption of intent between the two parties. Now, to see what this actually looks like in action, we have a short clip to show you what it actually looks like.
you can also sign using a PDF. And to do so, all you need is a PDF source. And you can use something as simple as a tablet device, which is a Galaxy, something of that nature, or an iPad. And the best way to do that is download an app. There's an app for it. It's free, as long as you agree to accept the terms and conditions of download. Now, once you have the app, you have the ability to take any document that's been submitted via email to that application in a PDF. And then all you have to do to sign it is click the old-fashioned fountain pen and add your signature. It's that simple. You can sign it, you can sign and save your signature for future use. I've officially signed this document, and once I put finalize, it'll be secured and it'll be submitted as an e-signature. So technology itself is quickly advancing. The iPad itself didn't come out until 2010, and it's going to be up for the courts, legislature, and the commerce to figure out how everything's going to work together.
And so with that, we come to the history of some of the legislative actions that have been taken in order to deal with this emerging issue of electronic transactions. Now, Utah, the Beehive State, actually was the first jurisdiction in the world to implement an electronic signatures legislation. And they did this by passing the Utah Digital Signatures Act, or the DSA, in 1995. Now, this represents more of a regulatory, or what one author termed the ABA-style approach to electronic signatures legislation. And now it's important to remember that distinction that we made earlier between electronic signatures in general and digital signatures, which are a subset of that. Those are the ones that use the public and private keys that we saw on Niki's flowchart earlier. Now what the DSA does is basically once you use that type of digital signature, one with a public and private encryption key, that creates a rebuttable presumption of intent. And so it's very difficult to invalidate the authenticity of that electronic signature. And there are no exceptions to the type of transactions that are covered by the Utah DSA. Now, on a national level, the United States has passed, or not really passed, but it's a model act called the Uniform Electronic Transactions Act, which incidentally enough was modeled after a UN Commission on Electronic Contracting Practices. They developed this model legislation on electronic commerce back in 1996, and the United States tweaked it and made it its own in 1999. And now this is a state-centric model adopted by the vast majority of US jurisdictions. I think 47 states have adopted it in some way or another. The only 3 that haven't are Washington, Illinois, and New York, as you can see in gold here, and even then they still have their own customized electronic signatures legislation. And what this does is it basically grants legal effect to any electronic records or signatures that would have an effect on paper. But there are a couple of exceptions. It doesn't apply to testamentary wills, trusts, things of that sort. And now in the year 2000, President Bill Clinton, with, I think he actually used an electronic signatures card, signed the Electronic Signatures in Global and National Commerce Act, or the e-Sign Act, in 2000. Now this represents a different style of legislation, a minimalist bottom-up type of legislation implemented on the federal level. While digital signatures may satisfy the requirements of e-Sign, the parties are actually free to contract among themselves what types of electronic signatures, what types of devices or symbols are going to be used in that transaction. But basically what it says is that, particularly for federal agencies, that no contract, no signature or record shall be held unenforceable merely because it comes in an electronic form. And that contrasts with UETA because this is at the federal level, and so it displaces state law where applicable. The Federal e-Sign Act allows companies to develop and implement a national e-sign process and encourages uniformity, particularly with federal agencies. It levels the playing field for electronic transactions. Once again, they're no longer insufficient merely because of the fact that they transmit through the internet in ones and zeros. But it's still important to remember that despite all these various ways of dealing with electronic signatures, that the substantive law itself remains unchanged. So even though you're dealing with an electronic transaction, you're still going to be dealing with basic principles of contract law, and you're going to be subject to the federal rules of evidence. Now, here we're going to get into a little bit of the case law that we've found that has basically found an electronic record or signature enforceable. And this is the Seagate case. This is involving an insurance company, a company that's providing insurance to its employees, alleges that the insurance company failed to recognize valid changes in the beneficiary notices that were sent via email and other electronic means because the policy was mandated that they be implemented only through written notice. And the insurer argues that the E-Sign Act Section 7001B2 does not make the acceptance of electronic signatures mandatory, which is true. There's nothing in the federal legislation that says that private entities have to accept electronic signatures. But the court denied their motion to dismiss because of a different provision in the E-Sign Act, 7001A12, which says that contracts shall not be unenforceable solely because an electronic signature is electronic. So what that did was basically render written notice ambiguous in the terms of the policy. And so that created, that allowed the court to deny the insurance company's motion to dismiss. And here's an example of a case where the court has found that this transaction was unenforceable. This is Prudential Insurance Company of America versus Prusky. This is sort of the inverse or the converse of the prior case. We're still dealing with an insurance company, but the insurer refuses to accept premium investment transfers by fax or any other electronic means. And the plaintiffs counterclaimed, alleging that the insurance company, by refusing to accept these in electronic form, that they were continuously violating that federal e-sign legislation that we were talking about earlier. But the court rejected their plaintiff's counterclaim because e-sign 7001B2, the precise provision that the insurance company tried to argue with in the previous case, expressly provides that the use of or acceptance of electronic signatures are not mandatory. So they don't have to, but once they agree that electronic signatures or records are going to be used, then they have to play by the rules.
And that brings us into the trend of case law. So as court review of e-signatures is ever increasing and the cases are working their way through the pipeline, it's interesting to see what determinations are coming out through the courts today. Most cases have found clearly in favor of an electronic signature. The fact that there is an electronic signature isn't an issue. What is at issue are things such as evidence and other requirements, as we've previously addressed and will continue to address throughout this presentation. In Lorraine v. Markle in Maryland in 2007, there was an issue of whether or not emails that were submitted as an attachment in the court record were admissible. And in the end, the court found that while e-signatures themselves they don't have an issue with, they do have an issue with the fact that the exhibits weren't authenticated. There were 13 violations of rules of evidence in the attempt to admit the emails into evidence. And the Markle case lays out 51 pages of technological detail that talks about digital photographs, talks about digital signatures, records, and e-signatures, among other various uses of technology. And in that opinion, it lays out ways that that technology could be used in ways that it wasn't used in this situation. Primarily, they had issue with the fact that the documents simply weren't authenticated. They had violations of hearsay rules and no original writing. That being said, Markle has left the door open for the e-signatures. Now, Campbell v. General Dynamics, which took place in the First Circuit earlier in 2005, held that e-signatures were fine, but you had to provide a minimum level of notice to an employee. In that situation, the employee had signed an arbitration agreement that had been emailed to him or had accepted it. And the consideration on there was that the body of the email itself did not provide sufficient notice for what was attached in that email, which would be the terms. And it also didn't provide notice of other terms or changes that could be found elsewhere. So there it was a matter of, if you want to change it or submit something electronically, it's sufficient, but you do have to provide notice. And that's going to go a little into intent, which we've previously seen. Paradise v. Eagle Software came out in Massachusetts earlier this year, just a few months ago. And in there, it was a similar review of whether or not an electronic signature would be valid. In the end, it came out that there's a quote that they used in there, where the employee himself, despite the fact that he did not read the arbitration clauses, could not be saved by his failure to read. In there, the ability to read the clause is different from whether or not the consumer has taken time to read them. As a business, you don't have to ensure that they've taken time to read everything. What you do have to show is that they've had it available, that they had notice, and that they could have read it. An interesting side case would be Labajo v. Best Buy. And in there, they address the system that the company uses. Basically, they say that if a business has enforced if a company has enforced a protocol that allows for an e-signature, it's fine. However, being consistently wrong in their process is not a defense, and they can be subjected to class action. We're going to talk about how you can be correct and in compliance in your procedure or process so that this case law does not apply to you.
This takes us to the importance of intent. Whether or not an electronic or tangible piece of paper has been signed is meant to symbolize the intent of the individual that is signing or accepting the terms of that contract. The UCC defines signature as a symbol that is executed or adopted by a party with present intention to authenticate the writing. The intention to authenticate is often the fulcrum of courtroom analysis when it comes to electronic signatures. In one case, International Casings Group versus Premium Standard, the court found intent. Through its analysis, the court will first look at the context and surrounding circumstances, including the party's conduct during the time of the transaction. Additionally, it will ask if the parties agreed to actually conduct transactions electronically. Now, there doesn't need to be explicit agreement to do electronic transactions. However, you can see that through the conduct of the parties. In this case, they found that the exchange of emails manifested the meeting of the minds between the two individuals exchanging emails from their work email and signing their name at the bottom to show that they were negotiating terms of the contract and agreeing to certain parts of the terms through email, and that was sufficient to show electronic signature and assent to agree to electronic contracting in that way. However, in Sawyer v. Mills, another case, intent was not found. An employer and an employee were negotiating terms of a bonus or a raise, and instead of actually electronically signing their name or knowing about it, the employee had secretly recorded the employer's conversation during this oral agreement. Because the employer did not know that they were being digitally recorded, there was no intent found for his intent to be bound by that electronic recording. Therefore, the court did not find that this satisfied the statute of frauds, and there was no intent in this case.
That takes us into what has North Carolina done. North Carolina has adopted various statutes to address e-commerce law. They've codified in statute 66-58.4 the use of electronic signatures. And as you can see, that says, all public agencies may accept electronic signatures pursuant to this article, pursuant to Article 40 of this chapter, the Uniform Electronic Transactions Act, or pursuant to any other law. Essentially, North Carolina has allowed for the electronic signature, and in the governmental agency environment, they have required that if you are going to accept an electronic signature, you must accept so, as previously addressed by Colin. And that turns us into the scope of e-commerce laws. How much does e-commerce really cover? Currently, it only regulates within electronic transactions among other public agencies. It doesn't control the realm of private business transactions. At least it's not making it mandatory within private business transactions. Under the federal area, in Article 2A, which addresses real estate, it addresses the common use of electronic contracting in e-signatures. Real estate transactions are often recorded with deed electronically. There was a mirror system put in place for electronic transitions, and that's been common. Now, this also applies to Article 2 under the UCC, but it doesn't apply universally. There are issues within North Carolina that will need to be considered. Contracts under Article 2, in review of them under law, is the next step for electronic signature laws, the best way to form what the future will be. It's only inevitable that when you have technological uses for records, communications, and other means of efficiency, and they're ever increasing, the law will need to review and change accordingly. We've spoken with Professor Srivastava. He's a professor over at Monash University. He holds multiple degrees, including a postgraduate diploma in cyber law from New Delhi and a PhD from Monash. He practiced law in India for 3 years and is currently a professor at Monash teaching in business and taxation classes. He also has published multiple papers and journal articles on the subjects of e-signatures and from a business and legal perspective, including one of the first business empirical studies on e-signatures in a review of Australian law. And he's graciously offered to provide for us his insight.
Now I would like to add to this presentation what I feel is happening with the technology with regard to contract. The whole purpose for which this technology of digital signature came into existence was for B2B contracts. However, unfortunately, neither digital signature nor any other form of electronic signature is being used for B2B contracts. Digital signatures are only being used in few areas, in few countries. For example, in Australia, the Australian Taxation Office uses it with the businesses, and in India, the Indian government officials or the district officers use it to issue identity certificates to its citizens. So digital signatures are being used. It's being used in more for e-governance, that is G2C, that is government to citizen, or for G2B, or B2G, with regard to business or in between business and government. But in other sectors, for the whole other sectors, which I mean B2B, it is not being used. So the reason why digital signatures or any other form of electronic signatures is not being used for B2B contract is that businesses don't want to take any risk when millions of dollars are involved, unless they are certain that it's a foolproof technology. So unfortunately, electronic signatures, including digital signatures, cannot guarantee that there would not be any security attack.
This takes us into the consideration of proper execution. While the international laws are not consistent within every country, within the United States, the e-Sign Act has allowed for a model form. It's important, however, to ensure that you properly execute any use of an e- or digital signature. As you can see in this graph, there's a description of the process, how a sale would take place, and how that information would be stored in the future. In the end, you must be certain that any electronic execution of an e-signature is well developed, tested, and used in a repeatable or auditable system. This graph demonstrates the beginning of the sale, the initial communication with your consumer. It takes you through to the execution stages, which we'll discuss, the orchestration, how you're going to work with the consumer, store documents, and the evidence, how you're going to store documents for future use, particularly with an eye towards potential litigation, although that could be rare. Eventually, it'll reach the back office where you have to worry about proper storage and availability and maintenance of your records. There are 6 common risks associated with e-sign that, according to Greg Kasimoto of Locke, Lord, Bizzle, and Lindell, should be considered, and they can also and should also be mitigated. These 6 risks will be identified and addressed throughout the rest of the presentation. The first one being the risk of authentication, when a consumer says, "That's not my signature." The second is an issue of repudiation. If somebody who has submitted an electronic signature says, "Yes, I signed it, but that's not what I signed." The third is going to be rules of admissibility. Can you get it into evidence? What will the court say about it? And then there's compliance. Can you make sure that your system complies so that the signer has seen all of the documents each and every time somebody goes through that portal? And fifth is an adoption. Make sure that you test and retest the system, as we'll reemphasize at the end of this presentation. And lastly, there's a relative risk. All things considered, do each of these items hold their own weight? Or are they significantly riskier than a traditional handwritten signature? And this will be discussed by my colleague, Colin Crawford.
Okay, so well, one of the people that we talked to during this presentation, or in preparation for this presentation, was Mike Phillips, who's a commercial litigator here in town at Bell Davis and Pitt. And while he personally did not have or know anybody that had any experience with electronic signatures litigation, one of the things that we discussed was, again, that the substantive law at issue is really not going to change, that you're still going to be dealing with some of the same common law defenses, you're still going to be looking at the same sort of evidentiary hurdles as any other contract dispute. But one of the things that he really that really struck out at me during our conversation was the fact that anytime you have a validity dispute, very frequently it's going to raise issues of fact, which means that the case is probably not going to be ripe for summary judgment. So that's why it's important to take steps to protect yourself before you get into these sorts of disputes, because once that litigation happens, then you're not going to get summary judgment and you're probably going to be in for the long haul. So basically we came up with a hypothetical to put a sort of a human face on it. We came up with the idea of 3 recent art grads, 3 men who have basically decided to start up their own small business called Durable Designs. And what they do is they take reclaimed airbags and seat belts and fashion them into high quality men's backpacks and duffel bags. And so basically they want to start up an online ordering process because they've had their urban scene, they've already saturated that market, and they want to start taking it elsewhere. So they have the technological savvy and the artistic flair to be able to do this in-house, but they've come to our firm to ask us for strategies to how to structure their electronic ordering process in order to avoid these sorts of validity disputes. And so the ABA's working group on electronic contracting practices actually came up with a list of 15 strategies for dealing with click-through or click-wrap agreements. Transactions. And so we're going to explore these right now. And they're basically broken up into a couple of different categories. The first of which is obviously the opportunity to view terms, because that's one of the most important parts. You need to make sure that you give full disclosure and that each page of the terms and conditions can be seen. The means of assent should be placed at the end of the agreement process. The ability to read the terms of the agreement, they should either automatically appear, they should be clear and conspicuous, some sort of hyperlink, some sort of indication, more than just a de minimis, it needs to be clearly visible and easily accessible for the user. General references are not enough, and these disclosures should come somewhere long before the order page itself. The user should not be able to access or otherwise use the website or the ordering process without having first assented to the terms. The user should have a fair opportunity to be able to read the terms at her own pace, whether that's by allowing them to scroll down and read everything herself, or just make sure that they're able to read it at their own pace. They should have the ability, ideally, to navigate backward and forward through the text if it appears on multiple pages. And they should be able to view these terms at any point during the assent process in order for them to know what they're getting into. And so the next category we get to is the display of terms. The format and content of terms must comply with applicable laws. If the state statute says that it has to be in a certain size point font, or it can't be in colors that contrast too much or that don't contrast enough, then you need to obviously apply with those sort of laws. It needs to be clear and readable in a legible font. When we're dealing with electronic signatures, we don't want you handwriting out the terms and conditions with your iPad. It needs to be clear and legible. And also the information should not contradict itself or be ambiguous. The user should have, as with any transaction, the user should have a fair idea of what they're getting into, what they're agreeing to, and how to acknowledge it. And this leads us to acceptance and rejection of the terms and their consequences. Now, the user should be given a clear choice whether to accept or reject the terms, and that needs to be at the end of the assent process. Words of assent or rejection should be clear and unambiguous. It's very advisable to avoid words like submit or enter or process my order, because those could indicate something other than I understand and acknowledge the terms of and conditions of the contract that I'm signing. The method of acceptance or rejection should be easily identified. It should be a button or a checkbox of some sort. It needs to be something clear. It shouldn't just be a process my order link at the bottom of the page. If the user rejects the terms, then that should end the assent process and kick them out of the website as best practice. They shouldn't be able to access the website. They shouldn't be able to continue in the transaction process at all, and they should have to start the process over again. And finally, the user should be made clearly aware of the consequences of acceptance or rejection. The best practice is to have a button that says I agree, or by clicking I agree, I acknowledge that I have read, understood, and acknowledged that I am going to be bound by these terms. And so that makes it a clear manifestation of assent. The opportunity to correct errors is our next category. The assent process ideally should include a reasonable opportunity for the user to be able to review the terms, like I said before, or be able to correct the mistakes that they're made. A summary of the final order just before final approval would be appropriate, in order for them to add or delete items that they might not have wanted, or to adjust the quantity. I know I do that all the time, where I type 2 instead of 3 or something like that. Basically, before the final get-go, they should have an opportunity to correct the mistakes. And finally, and this goes back to the e-Sign Act, basically what you want to do is, as with any business transaction, you want to make sure you maintain accurate records of the transaction, including ideally the steps that the user had to take during the assent process, as well as the identity of the user and the terms to which they agreed. But also making sure that you comply with relevant privacy laws. You don't want to be gathering too much information. You want to be able to ensure that the user has the ability to retain that record for his or her own use, either through being able to print it or being able to store that electronically somewhere. You want to ensure that the user and all other relevant personnel meaning in-house business employees, people that work with the records, have the ability to retrieve the record after the initial transaction for the period required by law. And finally, the best way to do this is to e-seal the document securely, which is called hashing. This is sort of what we talked about earlier with making sure that you can't alter, change the records without some sort of red flag popping up. Any alterations will be known, and the original will still be sealed despite the attempted change.
North Carolina has provided a flowchart that they plan to use should a case like this arise within this jurisdiction. This is just a pared down version of that flowchart that focuses more on electronic signatures, and there's really no evidence that has actually been tested within the court system at this point in time. The first question we start with is there a legal requirement for a signature? If that's the case, then you move on to the next. Is there a legal requirement, or does law allow for an electronic signature? From here, the paths deviate. First, if this is a business or consumer issue not involved with the government, courts will plan on following case law, looking to other jurisdictions or within business practices of that area. What type of business are they conducting? What is reasonable? What's expected? What are the circumstances of the case? However, if it's a protection issue, such as protecting security, preventing fraud, they'll look to the digital signature, the encryption, the security of the actual signature and document. And that is often leads you to the North Carolina Electronic Commerce Act, which allows it in certain types of contracts, and really questions, does this address the needs of this company? And if not, should we allow the North Carolina law to include public businesses, private businesses, not just public agencies? Additionally, on the step on the protection issue, you're going to have to define what is a signature. Is this a signature? And that can become pretty hairy, because any simple sign, handwriting can be a signature. So much can be a signature, just a click of the mouse. So you really have to look under the circumstances to see if it satisfies the statute of frauds, and that the individual who signed the paper or the document has actually shown their intent to be bound by this contract.
So with that in mind, what should you do for litigation prep? You need to just know your system. Know how the system's designed, know how to use it, know what the pros and cons are to that system, and then test it. Make sure that it's working properly, that it's storing all of the information you need properly, and that there's a proper trail for every transaction that takes place. One of the best ways to do this is not only testing the system, but also by having form documents drawn in advance. And what we mean by that is, as Colin pointed out, the likelihood of getting a summary judgment will be slim. You're going to have to pull up all of your documents and submit them to the court. The best way to do this is in advance, before any litigation is foreseeable. And in that nature, you'll be able to not only have your findings or your drafts to the court already established, you'll also be able to go through your system and make sure that every item complies with the necessary rules and regulations and the rules of admissibility. You should also know of somebody who can and will testify in a court if necessary. They need to be aware of the technology, how to use the technology, and they need to be able to speak in layman's terms, both to the judge and also to any jury if it ever goes that far. Test the system, retest the system, and tweak accordingly. And most importantly, be consistent with how you apply your business procedures. This brings us to the question of the federal rules of evidence. As noted in Markle, one of the biggest issues was that there was no authentication of the emails, the electronic signature signed documents that they were trying to admit. The best way to ensure that you meet under 901A, the rules of authentication, is to show that you have a full audit trail. Who saw what? When did they see it? How did they see it? One of the easiest ways to do this is to ensure that you have a trail. And in that trail, you know that each person has seen this link, and then they sent to this link, and this is what they saw here. This is what time they saw it. Then they were sent to this page. These are the terms that they saw and the times that they saw it. If you continue to have a security trail that's hashed, as Colin discussed, so that it can't be altered without notification, then you're more likely, or you will meet the rules of authentication. Markle addresses a lot of the specifics of this technology and how it could be done in their rather lengthy court report, which can be found online. Experts. Not only should you have somebody who can efficiently explain the technology of your business system itself, but there are other types of experts that should be considered, and we'll go over these momentarily. They are network security specialists, handwriting and signature analysts, voice recognition experts, and somebody who's able and knows the system of electronic notarization. Experts so far are rarely needed in litigation in this area. Most contract disputes aren't related to the authenticity of the signature or the identity of the contracting party itself. The general question turns on whether or not there is a signature, not whether it's your signature. And that goes back to the items of intent. What were you signing? Did you intend to? Regarding the first type of expert, the network security specialist, you should have somebody who has analyzed your network security system. They've done network forensics, and they also provide in data security. You should have reports that are provided that concern the computer security itself against intrusions, hacking, and also that lay out your policy, both for users within your company and users outside. You should also be able to address other information such as secured computing, whether or not there's going to be information that shouldn't belong, and what the risk is of having your application or your system subverted. For the realm of handwriting and signature analysis, this is newer, especially because you're signing within the technology itself. They are a less classic document than what would happen if you take a pen with a paper. Handwriting analysis with pen and paper are already common. They know how to work, they've been used and addressed by the courts and accepted. The difference between a click and tablet signature will be a little dicier. It's harder to show any type of analysis when somebody's clicking. But as you saw earlier, the analysis that can be performed with your e-tablet itself in the signature you've put on here will be similar to the analysis of a standard handwriting signature. Deviations taken into consideration for the electronic form and how that's saved, secured, and written. While those experts aren't common in the field at this moment, they are up and coming, as is the realm of voice recognition. Now, voice print identification combines the oral part, or the listening, with a spectrographic comparison. And in that, they're able to take two voices and compare one to the other. And with that, they can know if the voices match the identification of who they already have a stored voice print for. The Fourth Circuit has held that voice recognition evidence in expert witness testimony is admissible under McCormick. These trends are up and coming. There's already phone systems that are out that are developed so that if somebody's speaking into the phone and the phone recognizes that the voice is not the owner, the phone itself will stop the call and close it down. And we have a link of that available online for your use if you'd like more information.
The fourth and final type of expert that's typically seen in this area, realm of electronic signatures, is an e-notary or an electronic notary. So what is an electronic notary? It's a fascinating area of notarization that has sprung up simply due to the electronic commerce and electronically signing documents. There are a number of signatures that require the use of a notary public to actually, sign and seal that they observed your signature and authenticate what you have signed. So that has been transplanted into the electronic format, and now an electronic notary can perform the same function, but in an electronic format. E-notarization is the official act of acknowledgement, verification, or proof performed by an electronic notary public. The certified e-notary attaches their electronic seal and signature on an electronic document just as they would if it was a tangible document. The difference is actually pretty small. It's simply the way it's performed, whether it's electronic or actually with pen and paper. In fact, all the requirements that have to be in place for a pen and paper tangible document notarization actually are in place for electronic signatures as well. In fact, that notary public must be at the computer with the individual as they sign the document. They must observe the signature in order to notarize it properly. Currently, there are 12 states that recognize e-notarization, including North Carolina. And in North Carolina, in order to qualify as a certified e-notary, you have to be a notary public already. You need to take a 3-hour course on specifically addressing electronic notarization and the requirements of that. And they must pass the notary exam with an 80 or better, then submit an electronic registration form so that they can be seen by the state as an electronic notary.
Now, basically, in the end, if you do find yourself in court and you end up, as a lawyer, if you're making the closing argument, one of the best things that you can do is to point out that holding that electronic signatures are unenforceable would essentially bring down a major leg of international commerce these days. Think about a world in which there are no more iTunes purchases, no more Amazon.com purchases or Kindle. Basically, all you have to do is point out that this technology is not only used in private businesses, but also in government agencies such as the Department of Defense. It's used by private organizations such as insurance companies, mortgage lenders, and banks, and also the IRS. And here's Dr. Shristava again with the future.
But fortunately, both law and technology are working together to promote the usage of electronic signatures. Efforts are being made at international level for the interoperability of electronic signatures. United Nations Commission on International Trade Law recently came up with its model law, but a convention on the use of electronic communications in international contracts. However, very few countries have signed it. Australia has not signed the convention. United States has not signed the convention, so it has not been ratified yet. It has not taken the shape of treaty yet. So yes, efforts are being made on the national and international fronts. and it will take maybe few or maybe many years before we see the wide use of electronic signatures for B2B contracts. On the other hand, as Kathleen, Colin, and Niki have shown, electronic signatures such as PIN and I agree buttons would be on the rise in the area of B2C and G2C, and you will see many more forms of electronic signatures in this area, and as there are few risks involved.
And so basically, just to sum up, to remember the best practices and the takeaways from today's presentation, basically as a client, what you want to do is build the e-sign process so that it is clear that the user's intent is to accept the terms and conditions, because ultimately that's the fulcrum that the court's going to use to decide whether or not this transaction is going to be enforceable or unenforceable. Another thing you want to do is, again, create a reliable business record of what the signatures evidence in terms of intent, and include a clear link to what the e-signature covers. You want to implement secure and, most importantly, recreatable audit trails that show the entire electronic transaction process, so there are no stones unturned. And basically that concludes our presentation on electronic signatures. If you'd like, we developed a Facebook page with some additional content. If you go to the top of your Facebook search bar and type in E-Signatures Task Force, that'll take you to the web page. We'll actually go through it in a minute. We have some links to some recent news developments. Sony updated their PlayStation Network terms and conditions just a few months ago, and actually just a couple days ago I turned on my Xbox and I had to sit through and scroll through 10 minutes of additional terms and conditions that I was signing, and it clearly said accept or deny. And so these sorts of things are happening every single day. You link to go to the Facebook page and explore some of that additional content, take our poll, and if you have any questions, feel free to email us at team.e.sign@gmail.com. Thank you very much.